Hi everyone, good afternoon in Alberta. My name is Karen Tereposky. I'm an associate, a senior associate with Samfiru Tumarkin in Calgary, and I practice in employment law and do some human rights work. We're here today to talk about your questions, whatever comes in with regard to employment law and any other related issues. So I'm here to answer those questions, and I am ready to go. If you have any, put them in the chat and I'll try to deal with them the best I can. As we're waiting, I guess, for those questions to come in, just can, I guess, touch on some items that are in the news. You might have heard about the Hudson's Bay insolvency proceedings. Sounds like they're about to file for some creditor protection, and that can be stressful for employees when their employers are, looking at bankruptcy or other alternatives like that, and can lead to a little bit of panic because obviously people think they're going to definitely lose their jobs, and that may or may not be true. Sometimes when employers or companies look for creditor protection, they're not necessarily shutting down operations, so they may be just restructuring. And if there are layoffs, there are some statutes in place that protect your rights in those situations, and you can make a claim in the proceedings sometimes. So there's a lot of layers to that issue. So if you are an employee of a company that's maybe looking at creditor protection, all is not lost. If it happens, reach out to us and we can help explain to you what your rights are and where you should look to get those rights enforced. I do have a question now that's come in. It says, can an employer terminate you in order to rehire you and promote you? I was recently trying to determine my vacation entitlements and was told that I was fired and rehired into my new full-time job. My ROE shows that I quit, but I didn't do this. Is this legal? Well, that is a weird one. Employer can terminate your employment, but if they're terminating your employment, they should be, if they're going to do that, they are supposed to provide you with your entitlements under the Employment Standards Code. So those are your minimum entitlements, even if they are hiring you back in a termination situation. They are supposed to provide you with those minimum entitlements, and those, how much those are depends on how long you were employed. It's odd that the ROE shows that you quit if you didn't do that. What they're trying to do there is say that you resigned. I would say that you should, send an email or write a letter that confirms that you did not quit, because they're trying to set you up to not be entitled to those minimum requirements. Also, though, as far as what your entitlements would be down the road, those 2 periods of employment would, they'd be considered to be one anyway, because it doesn't sound like there's really a break in service. I think the big issue here is that they're trying to say that you quit, and you need to make sure that that's not, like, that you don't agree to that. So I think the only worrisome part for me, it's a strange situation, but the worrisome part for me is that they're trying to say that you resigned. So you should make sure that that's not, that's not something that you agree with. Like I said, maybe send an email or a letter or something and say, I noticed on my ROE, it says that I resigned. I did not resign, and I'd like that changed. And then, if it does turn into a termination without cause, you are entitled to your statutory termination pay. Weird situation. I don't agree with the resigning piece. And if they fight with you on that, I would come talk to one of us at Samfiru Tumarkin. Reach out, because that's an odd situation and they doesn't sound above board at all. Hopefully that answers that one. I have another question that's come in here from YouTube. Can an employer let you go after 4 years of employment, claiming it is because you are underqualified for the job that you are already doing? Is this something they can change whenever they want? That's also pretty weird. If you've been doing the job, it's pretty hard for them to claim that you're underqualified. But sometimes what I've seen is employers start to decide that a certain job, they want someone with an MBA or whatever. If they decide to do that, they can terminate you without cause, right? That's not an illegal reason to terminate someone. So, in your job, say they go, okay, you've been doing okay in this job, but we want, to, for outward reasons, maybe they want to advertise that they have people with MBAs or something like that. So they want to change the job requirements, and they want to let you go, and they want to hire somebody who has, say, an MBA or some kind of degree. That's fine. They can terminate your employment, but they have to provide you with proper severance. An employer can terminate an employee's employment really for any legal reason. So as long as it's not discriminatory, an employer is allowed to terminate without cause. But in a without cause termination, they have to provide you with proper severance. So if you want to know how much they should be providing you, you can use our resource, which is the Pocket Employment Lawyer, to calculate your entitlements. It can give you a good idea of what you should be getting in that situation. And, if they're not offering you something close to that, come talk to us and we'll try to get you the right amount. So I guess in summary, it's not illegal for an employer to terminate your employment in that situation, but you should be getting proper severance. Next question is, I've worked for this company for 5+ years. They've always demanded that we arrive 15 minutes earlier than our start time and state that if we don't, they will reduce our pay. The pay rate is $24 an hour. My start time is 8 a.m. If I arrive at 7:47 a.m., they dock my pay to $22 an hour. Is this legal? That's a really strange thing again. Generally, with changes to your rate of pay, it requires a certain amount of notice. I think it's 2 weeks under the Employment Standards Code. I'd have to double check the amount of notice that you're supposed to get for reductions to your rate of pay. I suppose if it's a policy that you've agreed to, if it's written somewhere and you've signed off on it, it becomes part of your employment contract. So, is it legal? I guess it depends how they've implemented this process. It's definitely a strange process. I don't know why, if you're not there 15 minutes before your shift, they figure that that's okay to do. But if they've made it some kind of policy that you've agreed to, or if it's part of your employment contract and you agreed to it, then, it's a strange thing, but I guess if you agreed to it, then it would be okay. If it's just something that they're changing on a whim every time somebody comes in late, then, I think they're violating that notice provision in the Employment Standards Code about deductions to pay. So I guess that's the typical lawyer answer, is it depends, but it does depend how they've done it. And I guess there could be a legal way to implement that in the workplace, but it would have to be pretty specific. So if it hasn't been something that's agreed to, I would say not necessarily right. And, if you have some more information on that, it might be a good idea to reach out to us, and, we can look at kind of all the policies and that kind of thing, and find out really whether or not this makes sense. So next question from YouTube again. It's my first time getting laid off. I've been working as a legal assistant for 4 years. This is also a small firm, and I'm the only employee here. My boss told me that they can no longer afford to keep me. The business isn't doing so well. They've sent me a written termination notice today, and it only lists my vacation pay as my final pay and no mention of severance. I looked it up, and it says severance is only for employees who have worked for at least 5 years or more. Is this true? That's definitely not true. I don't know where you've looked that up. In Alberta, severance pay or termination pay applies under the Employment Standards Code as soon as you've finished your probationary period of 90 days. And that's a codified probationary period. So an employer can put in a longer probationary period, but if they terminate after 90 days, they do have to pay some severance pay. It's the employment standards minimum. Under the common law, severance can apply even before that 90 days. So common law severance, which is over and above what's set out in the Employment Standards Code as a minimum, definitely applies right away. What I'm not clear on, I guess, in your email is whether or not your employer has provided you with working notice, because that is a way to provide notice and not have to pay out severance as a lump sum of money. So I'm not sure if they're closing immediately. And this is a written termination notice today. So, if they're saying, well, here's your termination notice, you're terminated today, then you should be getting something. If it's, here's a written termination notice, we're closing in 4 months or in 6 months, then that's what's called working notice. So that basically is your severance entitlement, but it's given to you by way of working notice. So what an employer is supposed to do at first principles is give working notice. They're supposed to say, we're going to end your employment in 6 months or whatever the applicable time would be under the law. And then you're supposed to get to work until that period is up. And then, hopefully during that time, you're able to find something to replace it. And then when the 6 months is up, or even before, if you find something sooner, then you just go to your new job, and then you've been bridged to your next comparable job. And that's really the whole idea of severance. So that's really what they're supposed to do. But if they haven't given you that working notice, and most employers don't want to, because they don't want employees hanging around knowing they're only going to work there for a few more months because they're not as productive. So if they haven't given you that working notice, you're entitled to severance. And the 5-year thing is definitely not true. If you Google it, maybe sometimes you come up with some US law, right, where in some jurisdictions there's no severance at all. But in Alberta, that is definitely not applicable. So if that's happening to you, I would definitely suggest you reach out to us and see if we can do a consult with you to get you some more. Or get you some, I guess you're not getting any, so get you some severance. Next question. I got wrongfully terminated from a unionized job and got my job back in the end. The company and union agreed not to give me back pay, but I do want my entitled back pay. What could I do? So generally in our practice, we don't do a lot of union related work because that's sort of a different question. There's always that collective agreement that defines your rights. And that's, something that you need to look at and talk to your union rep about what that back pay situation is under your collective agreement. Because under regular employment law, there are not collective agreements. But it's difficult to answer the questions in a unionized situation because there is a collective agreement that governs your rights, and there's a union that's supposed to be representing you. So as I mentioned, we don't often do unionized work at Samfiru Tumarkin, but I would suggest reaching out to the union and trying to see how that can work, and they are supposed to represent you in that kind of issue. Okay, there's another question again from YouTube. Can an employer let you go claiming it is a forced retirement? My mother is being let go after 9 years with her employer, offered $7,000 as compensation. In certain situations, certain jobs that might apply, but I would say it's very, very, very rare. In general, unless there's some contractual agreement that says that is okay, it's not. A forced retirement isn't usually a thing. Also, with that situation, if they're telling her that it's a forced retirement, it's clearly an age-related termination, and that's likely a human rights violation. So the reason they're offering her some money is because they want to get a release from her that says she's not going to pursue them for more money as severance, and she's not going to make a human rights complaint. And I'd be willing to bet that if you look at that offer, there'll be a release attached to it saying, we'll give you $7,000, but you have to sign this release. And something in that release is going to say you're not going to go to the Human Rights Commission on this. So I would say probably not. That does not sound very legal. There's likely a human rights violation there. Whether or not $7,000 is the appropriate amount of compensation, I'd say probably not, but it does depend how much your mom makes, because it's going to be a sort of it's a figure of how long she's been there and how long her severance period would be. So I can't really say whether $7,000 is appropriate, but if we knew a little bit more information, we could take a look at that and kind of see like, okay, that's a fair offer. I would say, though, that there definitely is a human rights or a potential human rights element to that. So, I would talk to someone and look into that and get that severance package assessed and see if it makes sense to accept. I'm going to guess no, but I'd need to know more information. Another question on YouTube from Renee. Can an employer require to see your tax returns before offering severance if you were classified as a dependent contractor? Can they require to see your tax returns? I don't know what your tax returns would have to do with your rights to severance if you were a dependent contractor. Your tax liability and whether you were claiming taxes or how you claim taxes is a matter between you and the CRA. That really doesn't have anything to do with how much severance you're owed, other than in the context of, if it was a while ago that there was a termination, there is the concept of mitigation of your damages resulting for wrongful termination. So you can be wrongfully terminated as an employee or as a dependent contractor, and your entitlement is the same. It's to severance. The caveat sort of on how much severance you're supposed to get is that it does depend on, your duty to mitigate, which means you have to go find other work. So sometimes we do disclose tax returns in that period after the termination. So say the termination was a year ago, sometimes the employer will want to see how much you earned in that year, because that could be a deduction from what they would owe you in severance for that year after your termination. But if you're just being terminated now, I don't see how that's relevant. So again, if I had more information, I could answer that more fully. If you need to have that looked at, please reach out and contact us at Samfiru Tumarkin, and we'll look at that and let you know what our thoughts are on that and whether that really is something they can do. It sounds fishy for sure. A question from Carrie from Facebook. I'm looking to change my job, and I've been interviewing with a much larger company in a similar industry, offering much more products and services though. I was reviewing my contract with my current company to see how many weeks notice I would have to give, and I came across a 12-month non-compete section. I know this is normal and usually not a big deal for someone in a small role, but will this be an issue? This comes up a lot. I would wonder if it's a non-compete or a non-solicit, because there is a difference there. A non-compete, often those are very hard to enforce. If it's a non-solicit, basically saying they can't, that you're not allowed to solicit their clients for a year after termination, that's a different type of clause than saying you can't work for a competitor, because that's a non-compete. So I'd be curious to know whether it really is a non-compete, because most people refer to them as that, even if they're non-solicits, or if it is actually a non-solicit. The issue with it, I guess, for you, and this is what I tell a lot of people, whether or not it's drafted well enough, whether or not it's actually enforceable. The issue is going to be, if you're interviewing, most of the time when you're offered a new job, your new company is going to ask you, are you subject to any restrictions from your last employer? Are you subject to a non-solicit? Are you subject to a non-compete? And some employers, when you say, yeah, I am, will be like, well, you know what? No thanks then, right? So that's a bit of the issue, whether or not it's enforceable or not. A lot of times employers don't want to deal with it. So I think that could be your complication. The other thing is that a lot of times when you sign off on an employment contract, it'll have language in there that says, I am not subject to either of these things. So, you may have to disclose it. You probably should disclose it to a new employer if it's in the same industry that this exists. What I have seen happen is some employers will look at them and say, you know what, we don't care. We're hiring you anyway. And if this other employer comes after us, we'll stick up for you. We'll have your back. I've even seen employers, new employers offer to cover legal fees if there is some sort of litigation that arises out of it. So that might be your biggest issue, is whether or not the new employer is okay with it, right? And people always, kind of have this impression, probably from, TV, that, a non-solicit's never going to be enforceable. I think what's sort of more scary though is that whether or not it's enforceable, if you go to a new job and your old employer writes you and writes your new employer and says you have a non-solicit and you're violating it, your new employer is going to go, what? Why are you violating this non-solicit? And then you're on the defensive, right? What you then have to do is have to make an application. You'd have to, get it set aside, or they would have to make an application for an injunction to stop you from working. And it can be a mess, right? So one thing that I do tell employees to do a lot of the times when they have these non-solicit or non-competes is, when they leave, to get a waiver from their current employer. Now, because you haven't been terminated and it sounds like you're just trying to move on your own, that might be a harder step. A lot of times people get terminated from one job and then they want to get a new one. their prior employer will write a letter that says, we'll waive the terms of this non-solicit in relation to this other job, because they want you to find a new job so they don't have to pay you as much severance. It could be a little bit more complicated in the situation where you're trying to leave. So I think it would be wise for you to get that provision reviewed by a lawyer, see, does it have a chance of being upheld? What are the risks for you? Reach out to us at Samfiru Tumarkin. As you see on your screen, you go to employmentlawyer.ca and get somebody to take a look at it. I think it's worth it because, whether or not that clause, that language is enforceable, it can turn into a disaster if, you don't properly handle it. So I would advise getting that looked at. So another question, looks like it's from YouTube too. I've been working for the same employer for 10 years. During this time, me and my family have been covered on a medical plan that pays for a very expensive drug my child needs. They recently changed companies and chose to remove that exact drug from the plan, knowing that they had an employee who was presently taking it. I've spoken to them and they have advised me that there's unfortunately nothing they can do. Is this a too bad, so sad scenario? Well, I hope they gave you at least some notice of the change in that plan, because you should have at least had notice so that you could convert that plan to an individual plan. That sometimes can happen, is that if you have a group benefits plan and you speak to the provider, you can go and convert it to an individual plan so that you're still subject to that coverage, even if you're not on the group plan anymore. It tends to be more expensive, but in your case with, an expensive drug, maybe that's worth it. So if this just happened, you might still be able to convert. So I would reach out to that provider and see if that's a possibility at all. With regard to, your employment relationship on this, I think it's a bit of a tough one because they're still providing you with benefits. Generally in employment contracts, it's, we're providing you with benefits. It's not specific benefits. The only way that you could argue that it, gives you some rights is that if it would be, a material term of your employment contract that they're on this particular benefit plan. And it might be a tough sell because they knew that, that's important to you. Maybe, but unfortunately, your remedy in that situation is going to be to claim a constructive dismissal and claim severance from your employer. So, the remedy would be basically leave the job and try to get severance. It's not to get that medical plan back. So I don't know if that's a good solution for you. Practically, I think, the best solution is to see if you can convert to an individual plan that might work the best. And maybe you could have some discussions with your employer about, getting off their current group plan and just instead, trying to get some coverage for the individual plan. So that's, hopefully that's helpful. I know that that's probably doesn't completely solve your problem, but hopefully that helps a little bit. So another question from YouTube. Should you sign a termination letter before your employer approves 2 weeks? Family caregiver leave. The letter is to be signed in case the leave is extended beyond 2 weeks. Job also not guaranteed upon return. Okay, I'm going to admit that I'm really confused by what's going on here. If you're taking family caregiver leave, you should not be getting a termination letter. There are leaves under the Employment Standard Code that apply and may apply in your situation. And if you're covered by, there's compassionate care leave, there's a few leaves. If you're covered by one of those, your job is supposed to be guaranteed on your return. It's an unpaid leave, but I don't understand why there's a termination letter if you're asking for leave. So I would say don't sign it because that sounds like something you should get reviewed to me. This doesn't seem like it makes sense. Sounds a bit fishy. I would say reach out to us and have somebody take a look at that. You don't want to sign a termination letter just to take 2 weeks because then you're depending on them to get your job back. And because I don't know any other details, I'm not even sure how much severance you should be getting if you are terminated. So I think there's definitely some issues that you should get looked into there. That doesn't sound right to me. Okay, another question on YouTube. After 9 months on the job, I was let go without cause. My 2-year contract was initially extended for 3 months, and I was told I could work for from home, which I did. Then a month later, I was told to show up for work in the office or else. I did come to work and was fired. My contract states I was to be given 2 months notice. What am I entitled to, please? That's, I mean, if your contract says you're supposed to be given 2 months notice, then I got to say you should have got 2 months notice. I would want to review the contract and, see what the language says. Based on what you're telling me, if your contract says you should have got 2 months notice, then yeah, you should have got 2 months notice. I'm not sure if they're offering you some notice or if you came to work and they fired you on no notice. But strange, again, situation. If you're told to come and work in the office and you actually came in, I mean, I don't know that they would have any reason to fire you without notice or any reason to fire you for cause. They should be giving you the 2 months that was agreed to. I'm also interested in what that clause says, considering you're saying it was a 2-year contract and it was extended, and whether the work from home requirement was actually part of the contract, because that's obviously going to be relevant too. So another situation where I think it would be really wise to get somebody to look at that contract and let you know their thoughts on it from a legal perspective and what that language says or means. Like I said, from what you're saying to me, if your contract says you're supposed to be given 2 months notice, then I would say you're entitled to 2 months notice, subject to reviewing that language. So yeah, that's my basic answer on that one. Of course, it's one of these situations where I feel like I need more information, which is, seems to be a running theme, but based on those basic facts, that's what occurs to me. So I don't see any more questions coming in, but if anyone feels the need to get these questions that you've asked today reviewed further, obviously you have that information. You have my name, you have the website. And you have our Pocket Employment Lawyer tool that you can use to find out how much severance you might be entitled to. That might be something that in your contract situation you might want to check out too, to see if that doesn't apply. Maybe you could try that and see what that tells you. But yeah, reach out to us at employmentlawyer.ca. The address is in the bottom corner of the screen there, and we can answer these questions in a lot more detail. Another live stream coming up if you want to tune in this Thursday, March 12th, 12:30 p.m. That's Eastern time, and that's with Alex. I believe he's out of our Toronto office. He can answer any more questions you have in that case, and hope to see you tuning in then. I don't know. It doesn't look like we have any more questions, so I guess unless any more come in, we'll probably be signing off here. Thanks for joining us, and I hope to see you next time I'm online.